All right, it is September 5, 2025. Welcome to Borderlines, a Canadian immigration law podcast. It's been a while since we described what the podcast is. I'm Steve Murins, joined as always by Danna Okanachoff. Last week she was hosting without me, but I am back. That was a
Actually,
great
last week we
episode,
had
by the way.
no episode, but the week
Right.
before we had, it was a great episode. And I've been like, my head has been spinning ever since, thinking of all the different applications of that intersections between constitutional and immigration law. It really did fill me up.
Yeah, no, I was getting texts and emails when I was in Oregon saying there's an amazing episode that Deanna just did with Sujit and Zainab. The podcast is always awesome, especially when you're not on it, which was always the fun type of text and message to receive.
That's great.
Um,
They come the other
it,
way when I'm not there, so don't you worry.
right. Well, Deanna, we'll see. We're hoping to do a full episode today. Deanna and I were both talking just before we went live that there's big wildfire smoke in Vancouver that has impacted, I think, both of us. I've biked to work until today every day this week, and I'm feeling it today. But hopefully our voices both sound okay.
Yeah. Yeah.
What the topic is for today's episode is the recent, I guess, media hoopla, political hoopla over the temporary foreign worker program in Canada and how it looks like this actually may become a big political issue going into the fall. We had earlier in the week Mark Carney in something that I just saw on X where he was quoted as saying the top two issues in Quebec right now are tariffs, as well as the ability of companies to hire foreign workers. And then you had that contrasted with what both the Conservatives said federally, as well as the Premier of British Columbia, David Eby. So I've pulled up the Conservative Party of Canada on its website today, has a press release out titled Canadian Jobs for Canadian Workers. And it starts by noting that Pierre Poilievre, who's the leader of the Conservative Party, recently back in Parliament, and Michelle Rempel-Gardner, who's the Shadow Minister for Immigration. Love to have her on the podcast maybe this fall when she introduces some private members' bills, has said that they will, quote, tackle the Liberal unemployment crisis by permanently scrapping the temporary foreign worker program and immediately ending new permits, end quote. So one of
With due
the
respect, our actual immigration minister feels a bit like a shadow minister right now. Very, very low profile for an immigration minister, particularly in a time of such frenetic change in the immigration field. So I feel like we're almost hearing more from Michelle Rempel than we are from Minister Diab herself.
Yeah, it's been interesting on that, and I'm not sure what's going on there. Maybe she just is going to be a less public-facing minister.
It's a good time to be less public facing because I don't think that there's a lot of positive things that are going to be being received right now in this field.
Yep. The so one of the questions that always gets sort of raised as the lawyer in me is when people talk about, abolish the temporary foreign worker program, what do they actually mean? What are they talking about? And there actually is some information in what the Conservative press release is saying, which is, quote, under this urgently needed plan, the temporary foreign workers program, and I'll just note that I'm highlighting too that they say temporary foreign workers program with TFW in caps locks and program in small letters, and they do that throughout the press release. So that's part of, as a lawyer, I get confused saying, are they trying to not refer to the actual program? Is it something else? Am I just reading too much into it? But anyways, the temporary foreign worker program would be permanently abolished with a separate standalone program for legitimately difficult to fill agriculture labor. For ultra-low unemployment regions, there will be a transition period of at most 5 years while the program winds down, but no new permits will be issued anywhere in Canada, end quote. So if I understand what the Conservatives are proposing, it is that there will be no new LMIA-based work permits outside of agriculture issued across Canada. And the way I read what they talk about a transition period for low unemployment regions is that they will cancel existing work permits within the program. That is something that is made possible, should it pass, by Bill C2, which we've discussed before. That's at least how I read what they're talking about, the actual cancellation of existing work permits. I don't know if you read it the same.
Yeah, I mean, I do. I'm not clear myself on how much agricultural labor is actually being run through the temporary foreign worker program and how much is being run through bilateral agreements between the government and various foreign entities. Like, I mean, it used to be that there were bilateral agreements, the SOP, and other similar agreements, like between Canada and Mexico, between Canada and other countries, where seasonal agricultural workers would come in. But I don't know if it's now predominantly workers coming through the temporary foreign worker program that are filling these positions in the agricultural sector.
Yeah. Well, we'll get to that in a bit, because the seasonal agricultural worker program is now just a subcategory of the temporary foreign worker program.
Okay.
And so it does become a bit of like, again, when they're talking about this, what are they talking about? What are they going to replace it with? This is not just a conservative issue. British Columbia Premier and former Borderlines podcast guest, David Eby, said that he also wants the temporary foreign worker program scrapped or significantly reformed, saying, quote, "The temporary foreign worker program is not working. It should be canceled or significantly reformed. We can't have an immigration system that fills up our homeless shelters and our food banks. We can't have an immigration system that outpaces our ability to build schools and housing. And we can't have an immigration program that results in high youth unemployment," end quote. So, I mean, he's using the word immigration system. I don't know to what extent he's referring to all that as a problem of the temporary foreign worker program. But the point is that from both the left and the right, there are now calls to scrap this program.
Yeah, they're pretty, like, that's a full spectrum from David Eby to Pierre Poilievre.
Yeah. So what is the actual temporary foreign worker program? And the answer, first of all, is that it's not all foreign workers. I don't have the most recent data in front of me, but in 2022, there were 135,818 foreign nationals who obtained work permits under the temporary foreign worker program, and 470,033 people who obtained work permits under the international mobility program. These programs actually used to both be the temporary foreign worker program. In 2013 or 2014, the last time there were big calls to reduce the size of the temporary foreign worker program, the government sort of cleverly divided the program into two: the temporary foreign worker program and the international mobility program. And I cynically think that it was just done to help stats manipulation, because all of a sudden there were media reports about how much smaller the temporary foreign worker program now was, ignoring that it was that a lot of it had just wound up in the international mobility program, which grew. You also see this on Reddit a bit, and in the media still, where there's confusion over people talking about the number of foreign workers versus the size of the temporary foreign worker program. And again, I guess the key takeaway from the last minute of what I've been saying is that the temporary foreign worker program, which is also what David Eby and Pierre Poilievre are talking about, is not the largest foreign worker program in Canada. But for the purpose of this discussion, since they aren't, as far as I can see, people aren't calling for the elimination of all foreign worker programs. We'll limit our discussion today to just explaining what the temporary foreign worker program is.
But it is really hard to distinguish from, like, the kind of what's happening in the public eye, because we don't know whether they're talking about more expansively temporary foreign workers, or we're talking about strictly the LMIA based work permit holders, which is what is technically the temporary foreign worker program.
And it's one of those things where, as lawyers, where we're so attached to terms and like these and programs, that we say, like, what is it that people are upset about? Is it the temporary foreign worker program? Is it the number of foreign workers? So just for a little more context, the international mobility program, which is the big one, includes postgraduate work permits, so people who graduated from Canadian schools, open spousal work permits, free trade agreements, significant benefit work permits, working holiday program work permits. Like there's all sorts of categories.
Yeah.
And then the temporary foreign worker program, which is also known as the Labor Market Impact Assessment Program, is where companies have to show that the hiring of a foreign worker will have a positive or neutral impact on the Canadian labor market. And there's a bunch of subsets within this program. There's the high wage and low wage stream, which has different recruitment rules. So for employers wanting to hire a foreign national, the general concept is that they need to pay what's called the prevailing wage, and that they have to show that they were unable to recruit a Canadian for the position. Those recruitment requirements can vary depending on what the wage is, but generally they have to post advertisements, including on a Government of Canada website called Job Bank. You have to post the wage or wage range. You have to invite people who are basically registered with Job Bank or EI to apply for positions, and then show that no Canadian could do the role.
And these recruitment efforts need to span a full month. So it's
Yeah, the
not.
recruitment needs to be a month, and one needs to be ongoing when the LMIA is in process.
Yeah.
There's also
And then you need to
agriculture streams.
justify why you're not offering the position to any of the qualified Canadian applicants for the role.
Yeah. Then, and I think this is important to understand in the context of the recent increase, because there's been a lot of media stories about how the number of foreign workers is rising. There are labor market impact assessments that are done until March of this year to get points for permanent residence. So if somebody was working for your company on an open work permit, they would not get points in the express entry ranking systems. If that company went out, recruited, got a positive LMIA, that foreign worker would then get more points, which would help them immigrate. So it was very tied to obtaining permanent residence. It no longer is, but that was a huge part, in my opinion, of the growth in the program was existing employees whose employers needed to get them LMIAs in order to have their employees qualify for permanent residence. With that being removed and people no longer getting points for arranged employment, that component of the program doesn't exist anymore, but it does explain why there was such an increase. There's also the Global Talent Stream, which is a niche program in which companies can either hire for certain positions in STEM or certain highly innovative and skilled positions that have certain salary levels. And in exchange, the program basically, the Global Talent Stream, is in exchange for no recruitment and very fast processing. The company has to commit to labor market benefits, hiring a certain number of Canadians, hiring a certain number of interns, investments in skills and training, knowledge transfer, revenue targets, all sorts of things. Then there's the caregivers.
Which is kind of a joke because caregivers, it's only for somebody who's already in Canada on a work and study permit. It's a very significant misunderstanding. People think you can use this program to bring in caregivers from abroad. You cannot.
Yeah. Foreign academics. So, our firm acts for a lot of public sector post-secondary institutions, and that's how schools bring in foreign professors. And so those are basically the broad subsets within the program. So when people are talking about eliminating the foreign worker program, it's not exactly clear if they're talking about getting rid of all of it. Primary agriculture has been talked about as being exempted. Foreign academics, I mean, I would assume that there continues that I'd be curious if both David Evie and Pierre Poilievre are saying that Canadian universities should not be able to hire foreign academics to teach. That being said, and this is part of what's unclear, is when they talk about scrapping the temporary foreign worker program, do they just create a new program within the international mobility program for foreign academics? Now, I do want to note within the context of the current calls to scrap the temporary foreign worker program, that there have been recent changes to the program, including two key ones. The first is that there was a determination made that there would no longer be low-wage LMIAs in areas of the country, central or CM or like metropolis areas of the country that have unemployment rates of 6% or more. So in British Columbia, for example, the median wage, the dividing line between low wage and high wage is $36.60 per hour. So in British Columbia, there are no LMIAs essentially because the unemployment rate, I believe, is higher in all areas of the province than 6%. The island may be the exception to that because I think the island for a while had a lower unemployment rate, but it is not possible to obtain a LMIA to employ a foreign national in most of British Columbia, most of the country, if it pays less than whatever that provincial median wage is, 36.60 in Ontario, in British Columbia, 36 in Ontario. That's not actually the median wage in the province. What they did as part of the September changes was to say, okay, we're taking whatever the prevailing wage was and increasing it by 20% for the purpose of this LMIA prohibition. So that was change one. Change two kind of stems and is really, I think, a new change as of Monday. And I'll just say that part of what you're seeing now is certainly Rebel News. I think Michelle Rempel-Garner, the immigration critic, has certainly been tweeting about this, that there are a lot of, say, fast food restaurants that seem to be hiring food counter attendants at that new $36 an hour wage. And so what has emerged are people saying, I don't believe that Canadians are not applying to be a food counter attendant. I'm not going to, well, I'm not going to name some of the companies, but like 36, let's just do the math. If it's full time times 52 times 40, I don't believe that Canadians aren't applying for a food counter attendant role at a fast food restaurant that pays $75,000 per annum. Probably a credible question, depending on the location of the job. So one thing that they have introduced to the program for the first time is something called direct apply. And one of the big issues within the program, and one of the kind of surprising things about the program, has always been, at least to me, that a company would go to the government and say, we have done recruitment and we could not find any qualified Canadians to do the job. Here is a spreadsheet of everyone who applied with the names redacted and why they weren't qualified. And in the whole time that I have been doing this, the Service Canada has not once asked to see the resumes of the people who applied to verify whether the company was telling the truth. Now, it could be that that does happen and I'm just not aware of it. But that generally, like, I don't know, at McRae, that must have been your experience as well, that they never asked to see the resumes.
Correct.
And so they always relied on companies telling the truth as to who had applied. That is now changing to the extent of the introduction of something called direct apply. And so what direct apply does is it allows job seekers in Canada who can work here, either they're Canadian citizen, I mean, it shows you either they're a Canadian citizen, a permanent resident, or a foreign worker, or they're outside the country. And direct apply, they can apply directly for positions that are advertised on Job Bank. And I'll just read what's on the Service Canada website. Quote, Job Bank's direct apply allows registered job seekers who are authorized to work in Canada to apply directly to your Job Bank postings by submitting their resume. By using direct apply, you can 1, manage and store all resumes submitted through Job Bank, 2, view and download all resumes for your records. You must consider job seeker applications submitted through direct apply. Direct apply is enabled by default. By disabling it or not considering direct apply applicants, you may be considered as not meeting the recruitment effort requirements, end quote. So what direct apply does, first of all, it was rolled out very sloppily because like it just appeared on job bank, something called direct apply. And so employers didn't know what it was. They didn't know if it was mandatory. It would ask, do you want direct apply? Some people would say, well, no, I want resumes to be sent to my email account. And the government would say, why didn't you use direct apply? And job bank would say, why aren't you considering direct apply? And employers would say, we have no idea what direct apply is. Now it's
when
been
did it come
explained.
online, Steve?
Oh,
When did they start?
It's been a
Really?
few months.
Okay.
Yeah.
Okay.
Well, I mean, and like it's been a few months because before it became mandatory within the program, Job Bank would start notifying companies saying, hey, you haven't been using direct apply. And people would say, what is it? So like, but it's been a few months. And the big thing, and kind of what could be the big changer within the temporary foreign worker program, is now Service Canada can see who is applying. And so my understanding is that as part of the assessment process now, at a minimum, Service Canada for employers where they're saying there were no Canadians at all who applied, the government will be able to say, well, no, we can see who applied. And they'll be able to say, you said that there were no qualified Canadians. What about this person? The names are still redacted. I'm pretty sure. I mean, I just can't remember off the top of my head if the names are redacted. But it introduces an element to the program that previously didn't exist, which is the government at least being able to vet the resumes, an accuracy of recruitment statements for applications that are submitted within Job Bank. How many people actually apply for jobs through Job Bank? I don't know, but
yeah,
that's at least the theory.
That's another question. I mean, the predecessor to this was Job Match, which is also part of the Job Bank, but it was sort of, it was a far less functional system in the sense that it created like matches to a job posting, but the matching system was inherently flawed in the sense that it would say, oh, this person is a 1-star or 2-star, 3-star match for your position, which might mean that they did speak English and they did have a bachelor of something degree, but they had never worked anywhere in the sector. And so it was of very little utility to either the employer using the system or to the department.
Job Match never made any Job Match is still there. You still have to invite all your 2-star or 4-star, depending on the wage matches. But I mean, you can picture it as an employer. So you have to go in and invite people to apply for jobs through Job Match. And all Job Match says is they'll say, person 36923 is a 4-star match for your mechanical engineering position because they have an engineering degree. Invite them. And it doesn't even matter if they have the same type of engineering degree. They would just, so you just click.
Yeah.
And then an
electrical engineer, never, a computer engineer. Yeah.
Yeah. Like Job Match never really made sense to me. Direct apply, I think has the potential to really enhance integrity within the program.
For sure.
I know it won't the politics probably won't be this nuanced, but there is a part of me that says, why don't we wait to see how direct apply does in addressing some of the concerns, at least until there's clearly thought out plan as to, well, what is the plan regarding who's going to work in roles? Are we just scrapping stuff entirely? Are we just doing a statistics maneuver of moving stuff to the International Mobility Program? But as far as integrity concerns go, I'd be very curious to see if direct apply does address a lot of these concerns within the program.
2 points here. I mean, I remember years ago, there was a case, I can't remember, somehow I feel like Laura Best was attached to it, where in the sort of the integrity, Service Canada did do a deep dive in terms of the validity of the LMIA application and did request resumes. And so I think for one, I wasn't working directly in that, but kind of as a peripheral observer, wondered if the time had come where they were actually going to start requesting that and doing more robust due diligence.
So that was HD mining.
Right. It was a Laura case, wasn't it?
Oh, that had Lauren Waldman working with the union Alex Stoichvik working for, I believe, HD Mining, and then Laura was working for an affiliated entity of HD Mining. Our firm, Lauren's affiliated with our firm, so we were kind of
Right.
a bit on that side. But what that case was, for those who don't know, is in 2012 or 13, there was big litigation where a union sought to have, I think, dozens of LMIAs refused that had been approved, set aside. So Service Canada had approved LMIAs, and the union stepped in. It was the United Steelworkers stepped in and said that these were approved unreasonably because the company advertised in Mandarin, and that qualified Canadians were had applied and were not considered. And it was, it stretched out for that was huge litigation for I think at least a year.
Yeah. No, it
And
was.
it led to the part of the first set of big reforms to the program.
Which perhaps led to job match, which again was to me, an ineffective way of trying to accomplish the same thing, some way of the government monitoring what had previously just been an honor-based system of you tell us who applied. I don't have any concern. In fact, I kind of support the idea of there being more direct due diligence efforts being made by the department. The LMIA process to this point has felt like a bit of a joke to me. This thing where you do the advertising, you put in some information and they respond. And the decisions that you've been mentioning, when people are now, well, you didn't talk about decisions, you talk about this trend of people now advertising at the higher rate to get out of the low wage scheme. I am seeing those and refusals coming from them. But there's actually nothing legally preventing somebody from increasing the salary. It's just that the decisions don't seem to be coming from, we have conducted a reasonable assessment and we believe that there are credibility concerns. That's not what's happening. They're saying you can't offer this wage, and that is not legally sound. And so, I think that having there be some system that says we just don't have a basis, the application doesn't support the contention that there is a lack of viable applications coming from Canadian applicants. And I do think this will furnish them with more information. I do agree with what you said, Steve, that whether or not those applications will come through Job Bank is another question altogether. But I think that there could be a technology solution here, including, the way that certain sites scrub other sites. And I don't know, but I think that the idea of this being an actual qualitative assessment of the applications coming through, because I think whenever we hear the department talking about wide scale change, they're big sweeping statements that don't look at any of the nuance in the program, to cancel the entire TFW program because there might be problems in this one place. To me is it's what we've been seeing so colossally throughout the system, which is using a hammer to kill a fly or a bazooka to kill a fly. And there will be impacts that will ricochet through the entire system, and it will absolutely prevent employers from accessing the workers that they require. A lot of people who avoided the temporary foreign worker program had no alternative but to return to it when the when the PNP programs got gutted, because if somebody was not subject to a free trade agreement or something like that, what other alternative did they have? And I think that when you're having this conversation, we do need to really talk about what's happening with the North American Free Trade Agreement. And if that agreement, I can't imagine trying to negotiate a new free trade agreement at this moment and what the lifespan is on the current free trade agreement that we have. But Canada is relying on, skills migration from the United States in particular to Canada. And the idea that we're going to be foreclosing the opportunity for Canadian employers to benefit from that, to be offering jobs to top level talent, because we have decided en masse that the temporary foreign worker program is filling our homeless shelters. It's just perhaps in some cases, but certainly not in all. I just think it's such a blending of so many different problems into one and not looking in a nuanced way at any of the multi-factors, multi-layers to what this program is supposed to service.
Yeah, well, it's all the government's conflicting goals. And it's been that trend on our podcast, certainly since Carney got elected, which was his pledge to reduce the number of permanent residence admissions, reduce the percentage of temporary residents in Canada, which, I'd previously said maybe they would just achieve it through more permanent residents, but the only way to both reduce the number of permanent residents in being admitted each year and reduce the percentage of foreign workers is either to let them work without a work permit or, which seems to be the approach so far, the expectation that people will leave. And I think British Columbia and Ontario's populations are slowly decreasing. But then there's that third thing that they want, which is to attract the best and the brightest. And then we can't forget the fourth thing, which is to attract francophones. So there's a lot of conflicting goals. My biggest beef with the LMIA program has always been also that it extended to people who are in Canada trying to maintain their jobs. And it was always
That we have no beef
bizarre and
with.
distasteful, but they needed LMIA. So if you were an international student, you get a 3-year postgraduate work permit, and the company wants to keep you, they need to conduct recruitment so that you can keep your job. And it puts the companies in this awful position of having to recruit to replace an existing employee, which has always been something that I find very distasteful about the whole program. But that speaks to a larger discussion about, bigger reforms to the system.
Something that got said at our immigration conference, though, that I think is really important and speaks to kind of what EB said is, I think it was Daniel, whose last name I'm going to forget, that we want to have on the show.
Bernhard.
Bernhard said, like, we fully appreciate that you want to keep more people out of the hospitals. But if you're going to remove this many people from the hospitals, you're going to also lose that many people from the nursing staff and from, the technical teams within the nursing facilities. And so the way that these reforms are being rolled out, you won't get one without the other. That lack of sophistication in how it's working is that, and that is something that I am experiencing truly on a daily basis right now, being called by nurses, doctors, not just professors, but like professors that are running entire departments that are sitting in wait for an application for nomination. But because either, in the healthcare sector, at least in British Columbia, they are still extending nominations to healthcare workers, not so for academics. But some of them aren't even able to get into express entry because of the federal skilled worker program requirements. And so, it's this crazy thing where it's like, you have a doctor with 10 years of experience, but they're single, they can't get into the federal skilled worker program. So they have to do a process that's going to take them 3 years to integrate. And again, it's like, are they going to do that? Or are they going to go to another competitor jurisdiction where they'll be given greater opportunities more immediately? They'll know that they've got that stable landing. It's just, I really, and I know that I've talked about this ad nauseum, but this whole idea of what is the Canadian brand? What is the message we're sending to those that we are supposedly looking to attract and retain?
Yeah, ce n'est pas un problème. Il pouvait étudier français. I'm sure I butchered that, but that is what, it's clear that there are a lot of challenges. Let's go to questions. We actually have several questions on topic, and not just, although we have express entry questions as well. But let's go to some of the first comments.
Take down the share screen of this page. Right. Yeah.
Simarjot Jasal says that one thing to add regarding the number of work permits being issued, the length used to be 2 years, now it is 1 year. So that was one of the other changes in September, was that the LMIA durations went from 2 years to 1 year. And Simarjot adds, which means that in order to maintain the same employee for the same duration, there are now 2 LMIAs being done. That's a good point. I hadn't thought of that before.
Because it could take I don't know how long it takes to obtain an LMIA right now, but like,
God. Well, it varies. The global
8
talent
months.
stream is like 10 business days. The PR stream is over a year. And then others are in between. But that
Yeah.
is a good point. By shortening the duration, they're just necessitating more applications.
Yeah.
So very good point.
Yeah. And the applications are just, as we're seeing, are being refused for such finicky stuff too, that just the volume of people just having, ticked a box wrong or something like that is just creating big volume again for the courts.
And then CKPD TV says it's being abused by small and medium businesses who sell LMIAs. $36 per hour is just to pass the low wage threshold. The employer will pay $36, then ask employee to return via cash, paying them just $15. I don't know the extent that happens, but that certainly is part of the speculation and some of the concern that does exist. I do a fair amount of employer compliance work, and that's always been an issue within the foreign worker program is companies that try to recoup wages from foreign nationals, which obviously is illegal.
Yeah. And the other thing too is what we're seeing then is that there is the scrutinizing of the LMIA application at the Service Canada level, at the work permit application level, especially when or at the permanent residence application level. What we're seeing is now IRCC not just asking for proof of employment, but asking for bank statements, asking for clarification about any deposits, any withdrawals, any deviation between the T4s and then and the bank statements and the pay stubs, like all of this extra scrutiny. I don't know what the solution is to this here, but I think part of the issue is that, it sort of goes to me to one of the issues that you mentioned, Steve, is that when you've got somebody who's a trusted employee and then you want to maintain that employment, the idea that you have to go back to step one and re-recruit for that position, I think that does increase the uptick of people sort of getting into a situation that in order to maintain that person, they're going to have to offer a higher wage. And it's sort of like, not to say that this justifies the abuse by small and medium businesses, but it has put people in quite a pickle. And so wanting to maintain that relationship. And so, but I agree with you. This is like, I don't think that this is a non-issue. I think that it's, when I think there's an over-regulation in an area, what we do find is that it creates a black market. Mm-hmm. And I think that's truly what's going on here. I don't think that this is a secret at all.
Yeah, the employers who I've acted for with compliance issues, as you kind of note, can be divided into kind of two categories. Those who are recouping funds for financial purposes, they just want to make money or pay less money. And those who were faced with a very difficult situation where their employee was saying, I need you to continue to employ me even though you don't want to, because otherwise I could be deported. And the employer saying, okay, well, we'll figure out some sort of a workaround. Not trying to justify it, although I do kind of understand that and again, it puts, employers are put in difficult situations where they may not want to continue to employ someone the way they had been, at the wage they had been, or the hours, or even at all. But that person's ability to stay in Canada with their family depends on it. And companies may work out solutions that are not legal.
For sure. Yeah. And it's challenging. But again, I think that a lot of employers, and I face this too, you've got an employee that you've really come to really, appreciate. You think they're great. Their whole family. They might have a kid who was born here, who has medical issues. You're just trying to do them a solid. And again, not trying to justify it, but they see the injustice in the way that they are being treated by the system. And they're trying to, again, I'm not saying that we should be overlooking this at all, but again, I think, people are trying to right what they feel is wrong in terms of people being sent packing after they've spent $100,000 on their education and then, done good work and now are faced with the you got to go.
Yeah. It's one of the issues of the closed work program, which we've discussed before.
Yeah.
Andy,
Any
frequent
situation,
commenter.
I just feel, okay, just going to say, I feel that any situation, you talked about this with Lisa Brunner, and I've rewatched that episode because I just think it's brilliant. But you talked in that episode about the idea of going from immigration to two-step immigration to three-step immigration. And it dawned on me when I was watching this that, like, I used to complain about the live-in caregiver program because it was this hybrid thing. It's like, come as a temporary worker, earn your right to permanent residency. And in the 80s, we remember the campaign with the caregivers like good enough to work, good enough to stay. And now that's come to dominate all immigration. Nobody, almost nobody, except if you're outside of the country and you speak French, nobody comes in as a permanent resident anymore. Maybe spousal sponsorships. But again, the number of people that are going to qualify from outside of the country and come in, it's dwindling. And that puts people into a situation where they're here. And, I know Minister Kenney said temporary is temporary, permanent is permanent, but humans move, they nest, they set down roots, their children do the same. And then this ideology that it's like, well, if you can't make it work out, then off you go. I think that is just proving itself not to be a viable way to run an immigration system. And the department seemed to acknowledge that when we were talking about this, when they were doing it, that the creation of a temporary resident underclass leads to consequences. And here we are. And now those people are being blamed for fraud. Get it? Fraud's not good. But again, it is something that has happened in terms of our way of dealing with that newcomer population. No settlement services, you fund your own immigration. And sorry if this is hard for you, but when you're done, you're done.
Yeah, I think we've gone from good enough to work, good enough to stay, and we're moving to good enough to work.
Yeah, that's it.
Yeah.
And even that, it's like, well, you prove it. You prove it.
Yeah. Andy says the program has to be reformed, but to be eliminated sounds similar, like Trump saying that Mexican are bad hombres to gain support from his MAGA movement. The conservatives are not offering alternatives to help employers and industries suffering labor shortage. The IMP is focused on skilled workers, but Canada needs workers in tier 4 and 5, which is lower skilled, especially with the demography and shortages in the labor market in certain industries.
Couldn't agree more. Yeah. Here. I mean, I think that I didn't expect anything more from Pierre Poilievre. Like, we know what his politics are. I'm disappointed in David Eby because the idea that, like, there's all these people in the homeless shelters, like, that's on us. The same thing with the international students. Okay, if you're giving people study permits to study at the school above the massage parlor, that's on us. The people that are applying from abroad are in no position to do their due diligence, especially when they can't get a visitor visa to come here and actually look and see where they're going to be studying. But when you look at the number of international students that come and fall into a massive depression, they're then blamed for having difficulties in schooling. Like, the lack of settlement services is real, and it has a big impact. So I think that there's a lack of ownership by Canada of, like, are we actually setting people up to succeed or to fail? And of course, more people, more unhoused. But again, I don't think that's like, I just think that there's a lot of finger pointing going on.
Where I'll disagree with Andy is that the International Mobility Program also includes the open work permits, postgrads, the open spousals, and I would imagine that a large number of them are working in those tier 4 and 5 positions. To the extent that Canadian companies can show that they need foreign labor for those positions I think direct apply is going to help show to what extent that continues to be the case. And it will be really interesting to see how the department now being able to see a portion of applications who apply changes the perception and possible reality of what the overall need for some of those LMIAs is. I've commented before that it's always a bit, you can walk from one fast food on one side of the street to the other. One will be foreign nationals, one will be high school students. And you will wonder, like, why it can't be the case that people aren't willing to cross the street. So what is going on? And we will see. I don't know what the actual percentage of fraudulent LMIAs was, and employers just making up that no one applied. But we will see. I feel like direct apply will help shine a lot of light on this.
For sure. I mean, I also have to say that like the IMP is also a good portion of spousal open work permits. And a lot of those spousal open work permits are being discontinued. You know that skilled workers in in a lot of occupations will not be entitled to bring their spouses. That's how they are going to achieve this goal of decreasing that amount. I think that that is going to substantially hurt the quality of applicants we're going to be able to recruit and retain, because the idea of coming to Canada being equivalent to coming to Canada without my spouse and family, I think it goes against charter ideology. Like I think the idea now, like the caregiver program back in the day, that we're going to be systematically depriving people of the company of their spouse and mandating that people who want to earn the right and privilege of Canadian permanent residence have to separate from their spouses for a prescribed period. Like, where did we come to this? Like, how did we come to this? Why do we think that this is good for immigration? Why do we think this is good for our communities? Why do we think this is good for what we are hoping will become the next generations of Canadians? And I think that what we saw with the caregiver program is that that next generation of children suffered hugely. And I mean, there were studies done on how many were dropping out of school. So again, I think we're working against ourselves by mandating that. So they are working tier 4 and 5, the second partner, it's still the overall effect that they are bringing into building community and raising the kids who are going to be the next generation of Canadians. So I think that, again, this is a very short-sighted measure. Like, bring the numbers down, but at what cost?
Yeah, I mean, I think the overall objective is just 7 to 5 by any means possible. 7 to 5 of the percentage of the country that's foreign workers.
Yeah.
Mohammed asked, since IRCC started the 2026 permanent resident quota, so would they conduct the trade draw, which was in 2025 quota? We have several comments on Instagram asking about the trades draw as well. There will be a trades draw in 2025. I am certain of it, that those applications will not be processed and approved by the end of 2025. So they will be part of the 2026 quota, but the draw will happen this year. And comments are coming in fast and furious. Tody says, to my understanding, the temporary foreign worker program was introduced because the federal skilled worker program experienced lengthy processing times, which delayed the arrival of immigrants to Canada. Subsequently, the express entry system was launched to prioritize highly skilled and educated applicants. Over time, however, many employers relied on the TFW program as it provided a faster and more accessible option. Please correct me if my understanding is inaccurate. That's more or less accurate. The foreign worker program was initially much smaller than it was now. Prior to 2000, I want to say 8, which was when the Canadian Experience class was introduced, there were not as many foreign workers doing the two-step that Danna described earlier and that Lisa Brunner talked about on our podcast, where the expectation was that someone would come first as a foreign worker and then apply for permanent residence. That was introduced under the Conservatives, kind of with the goal being to stop having skilled workers arrived and not being able to work in their profession. They will have already been working in Canada, and so they can continue to work in their role. However, what you wind up happening is, and where some of the concerns over, say, fraud lie, is that you now have a huge demand to be a foreign worker because it is step 1 of 2 to immigrate to Canada. And then B, you have the private sector essentially then determining there's now a price, right? Like the private sector kind of holds the keys to who gets to immigrate. And some people will be motivated other than what genuine jobs are. And so then some nefarious actors will get involved. But that's generally the history of the foreign worker program and kind of why it grew.
I think this is a really interesting point, though, because it's not just the federal skilled worker program. It's the federal skilled worker program and the Canadian Experience class are both, like, in both systems, you are advantaged by having Canadian work experience. So they both kind of presuppose the benefit of coming to Canada first in this two-stage immigration. The CRS system is the same. Even though it doesn't give points for arranged employment, it gives a whole bundle of points for Canadian work experience. So in effect, the department is kind of, it's almost like it's veering back toward a selection from overseas. Because ultimately it will be harder and harder for people to get that Canadian work experience before they can qualify, because the difficulty of getting that initial work permit. But again, like, maybe this is the overall end game, is that they want to move back to a one-step immigration. But again, I just don't know that there's enough material in the CRS ranking system, because it's not about certain occupations. It's not about, like, it's just such a blunt instrument for assessing the quality of an applicant. It's so situated based on age. The idea that anyone over the age of 46 is kind of over the hill and has little to offer us, I think that it's going to have a negative impact on the quality of applicants if there's no on-the-ground work experience and nothing else is added in to say, I don't know if it means going to an occupations in demand list. I don't know what, but I think that right now I have zero faith that it's selecting the right applicants. So
I mean, the way that it's going, it will be, if the Francophone levels and targets hold, it will increasingly just be Francophones and provincial nominees. Those two categories will probably crowd out most others. Tajinder asks, how many duties should match for LMIA-based work permit? I'm not sure if the question is just referring to like how to pick the knock. For the federal skilled worker in the Canadian experience class, I think the law is that they have to perform all of the lead statement and a substantial number of the main duties. When officers have refused on this in the judicial review context, the case that I've relied on to challenge the most is Benoit v. Canada, which is a 2013 decision. I can't remember the neutral citation, but it basically stands for the proposition that substantive doesn't mean all, and that there has to be sort of a qualitative assessment. One thing that also I, obviously recommend is don't just copy paste the duties from the knock.
Yeah.
And then the last one, the last comment, which was a super chat for $10, is charity start at home, respect is learned at home, hate start at home, reproductive health is ought to be an English founding father, and a French mother is the core of the nuclear family. You might think that that makes no sense. It makes as much sense to me as our immigration law and policy in a lot of ways right now. And I think that unless you have any other comments on either immigration law or Christian's comment, Deanna?
No, I will leave that.
Awesome. All right. Well, thanks to everyone who commented. This has been a great discussion, great input from people, especially adding on points that we hadn't mentioned during, I guess, the main segment on the topic, which was awesome. And yeah, we'll do it again next week. Oh,
one thing we have to remember is to tell people to subscribe to the channel, because we always forget to say that. And it really does help us in terms of our efforts to monetize so that we can continue providing the same content. We have some really exciting episodes coming up that we are working on, including a sort of deep dive into what's going on at the federal court and some thinking about that. So if you have any other suggestions, please don't hesitate to reach out to either Steve or I. We're always very
yep, definitely. Like and subscribe on YouTube.
Yeah, subscribe on YouTube.
Yeah, awesome.